So I just want, hello.
Sorry.
That's okay.
Okay.
So I just wanted to check if you can share your screen so that.
You have disabled it.
Yeah. You can do now. Yes.
A second. Yes. Should I share it now or? Okay.
Yeah, it's perfect. You can see.
Okay.
I think we can start now. Because
okay.
The participants can join whenever they're free. So okay. So good afternoon, everyone. Especially for those who are near in South Asia, because it's afternoon in most part of the South Asia, and for those who are in Europe, I guess it's evening already. No, I'm sorry. I think it's still afternoon. So
anyway, yeah, it's afternoon. It's afternoon. Yeah. It's not midnight.
4 p.m. in India. I think 12:30 your side. Right. So everyone, we have Mr. Damir Bonovich. He is an assistant professor at the University in Sarajevo, Faculty of Law. And Sir teaches introduction to the law, philosophy, comparative federalism. His main research focus is on the contemporary socio-legal theory of collective rights, minority rights, and consocialism and comparative federalism. So without making any delay, sir, I think we would like to discuss more about our today's topic. So let's start.
Thank you very much for inviting me for this lecture, and I hope it's going to be interesting also for you. I hope you're going to learn something. I hope also I'm going to learn something from you. So when we planned to organize this webinar, actually the idea was to talk about more on egalitarianism in comparative constitutional law, and so to see how how this concept is actually implemented in law. You probably know it's a topic which or it's a concept which is basically discussed within the political philosophy, but nevertheless it's very important also as a legal concept and basically legal principle. And more or less, especially after the Second World War, all of constitutions actually have some provisions granting equal treatment or non-discrimination. So I'm going to base my my lectures on starting with the simpler definition. What do we consider under egalitarianism, or what do we consider under term equality? So there are different terms in a sense. What encompasses under the concept of egalitarianism. We can talk about equality, equity, non-discrimination, etc. Then I'm going to talk a little bit more of types of equality, which is more or less from the political philosophy or political theory. Then I'm going to continue with international law and the case law. So what actually international human rights law tell us about the concept of equality. And then I'm going to end this lecture with the comparative constitutional law. So some dogmatic analysis, not going more into details, but to see how the constitutions worldwide prescribe or stipulate or how they define the principle of all equality, and what kind of mechanisms can we find in national constitutions. So what do we consider when we say equal treatment? It usually it can be defined as that people should get the same. So in this sense, we are talking about some kind of equal distribution of goods, services, or positions, or be treated the same, or be treated as equals in some respect. So usually the problem usually appears: who are the people? Or says who should be treated equally, and what's the foundation of this equal treatment. So egalitarian doctrines tend to rest on a background idea that all human persons or individuals are equal in some fundamental worth or have the same equal moral or the same moral status. So from this, actually, we encompass or advocate for the idea for equal treatment for everyone. The second part is going to be like what kind of types of equality, and then we're going to see these types of equality actually prescribed within the either international documents, some regional documents, or some national constitutions. So of course we can talk about different types of equality. I'm not going to go through all of them. I'm just going to put some ideas of these types of equality. But before starting this, I'm going to say, what does non-egalitarian says? It says that people believe that people born into higher social caste or favored race or ethnicity actually have some privileges or some rights comparing to other within the group or within the state or within the society. So norms of equality of condition of treatment might be viewed as freestanding or derived from the claim of equality of status. So it can be freestanding or it can be a claim of equality of status. So there are just different approaches. So the problem within the modern, I would say, modern political theory, it's to say, to specify the class of beings to whom egalitarian norms apply. So when we say it applies to human beings, do we say it applies to all human beings? So one perception is actually all and only human beings are entitled to equality status. Some would say that all and only persons have equal moral status with the criteria of personhood, excluding some humans from qualifying as such. For example, unborn fetus or severely demented adult humans who actually maybe don't have the capacity to make decisions on their own. But also within this concept, some non-humans, for example, some superior intelligent outer space can also claim to have. So like we can also see them as persons who have the claim for equal status. Some would also argue that also, I would say, non-humans are entitled for equal status. Usually we say, for example, for primates or animals, that they should also have moral status equal or similar to human beings, or they have some kind of moral status and they also should be treated in some sense equally. Usually, egalitarians aim to replace social hierarchies with relations of social equality on the grounds that individuals are fundamentally equal. So usually, egalitarians attack social hierarchies. So what kind of social hierarchies we had or still have? It can include the social hierarchy, which usually egalitarians attack, can include slavery, feudalism, monarchy, oligarchy, caste, social inequality, racism, patriarchism, colonialism, stigmatization based on sexuality, disabled, and bodily appearance. I would say more in the sense of political theory and theory of state, how we actually can reach equality within one society and one state. There are different kind of mechanisms or different kind of arrangements. For example, we had experiments or tries with communism, state communism, anarchism, syndicalism, multicultural, which is still something viewed as a possibility to more include discrimination based on ethnicity or nationality, or protecting some groups within the society which have some ethnic or national characteristics different from the majority within that state. We can talk about 4 kinds of equality, and you're going to see that within the international documents, national constitutions, there are these types of equality actually presented within the national documents. So we can talk about political, legal, social, and economic equality. Political equality it's quite simple. It's actually based on the idea that all mature adult citizens have the right to be political participation, simply to elect or to be elected. This can also, from the perspective of multiculturalism, this can be said. This can actually it can encompass national minorities in sense to be represented within the local governments. In some multicultural society, this also can mean that ethnic groups have the right to be represented via a system of quotas, or they have some kind of veto mechanisms. Of course, this is the right of women to political participation, indigenous people to have special rights. For example, you can see that in Canada, for example, in some cases in Great Britain, also in Bosnia, Belgium, Switzerland, etc. Legal equality is actually something which is more present within the, or I would say more something which legal practitioners and legal theorists actually focus more. It basically says that legal equality includes matters of fair treatment and legality. This actually means that courts, for example, administration, should treat similar cases in an equal manner. And then the norms should apply equally to same or similar cases. Of course, social equality and economic equality is something which we have discussed. Economic equality, for example, it's more actually communism, socialism used to be more focused on this idea of economic equality, in the sense that all should have the same, or the wealth should be distributed the same. Or in a modern sense, it means equal payment for equal jobs. Of course, there is a criticism of the concept of equality. It means that if you apply equality, it's something which you can't implement. And it's actually against the human nature, and because people or human beings differ among each other on basis of their creativity or intellect capacities or their abilities. So of course they're gonna differ within the society or within the state. So actually that would be abolishment of freedom. So the natural tendency towards inequality can only be counteracted by authoritarian violence against individual abilities and aspiration. This is actually a very legitimate reason to base critics, but actually there are arguments which we can oppose to this. Of course, I'm not going to go through all the theories of starting from Aristotle, Plato, Aristotle, some modern communitarian perspectives by Michael Walzer, or some liberal perspectives by John Rawls. So there's a lot to say about equality and the problems within the equality, and also about the liberty or the freedom. But I'm not going to talk about here anymore. So I'm going to focus more on something which is international law and the case law. So in a mother, so we can't in a mother states or in modern democracy, we can't talk about constitutional law without taking into account international law, or more concretely, international human rights law, and of course the case law. And first, I'm going to start with this general comment number 18, published by issued by the Human Rights Committee. Of course, you know it's a body within the international organization UN, and it stated in its comment 18 that non-discrimination, together with equality before the law and equal protection of the law without discrimination, constitute basic and general principles related to the protection of human rights. So you can see this theories within the political philosophy actually somehow legally implemented within the international documents. When we talk about the most important human rights documents, we have different definitions or different concepts. For example, principle of equality, non-discrimination, stating that those in equal circumstances are dealt with equality, both in law and practice. Within the brackets, I put international documents and articles in which you can find these principles in more detail. I have already sent this presentation, so you can, if you're more interested in going into details, you can check this on different documents, on international and human rights documents. But if you say you're probably aware of this concept, not every discrimination it's against law, so to say. So it has to go through a so-called three-party test. Especially when we talk about international human rights law. It has, in international human rights law, evaluation of the principle of non-discrimination arrives if A, equal cases are treated in a different manner, B, a difference in treatment does not have an objective and a reasonable justification, and C, if there is no proportionality between the aim sought and the means employed. This is very, very common, I would say it's a common knowledge of this three-party test. Also in the brackets, I put case law. For example, this has been established by the European Court of Human Rights in the case Marx versus Belgium. And this principle, which has been introduced by this case, you can find in paragraph 33. Also, some regional documents prohibit discrimination or they require equal treatment. For example, American Declaration of Human Rights and Duties on Rights and Duties of Man, African Charter of Human Rights and People's Rights, American Convention of Human Rights, Cairo Declaration of Human Rights in Islam. So also not just not just only universal international documents, but also some regional documents also prescribe the principle of non-discrimination and principle of equality. Also, if you say equal treatment, this doesn't mean that some kind of unequal treatment is prohibited. This is something which we call preferential treatment, or in a theory, it's called affirmative action. So equality sometimes requires for states to take affirmative action in order to diminish or eliminate conditions which cause or help to perpetuate discrimination. This is something very present also in national constitutions, especially in statutory laws, anti-discrimination laws. So preferential status doesn't mean that that you breach actually the principle of non-discrimination, but actually you're bringing some disadvantaged groups into position of equality or equity, to be more concrete. This can actually cause this action may involve granting for a time to the part of the population concerned certain preferential treatment in specific manners as compared to the rest of the population. So preferential treatment for national minorities, women, indigenous people. Also, if you're more interested in this, you can also check the general comments, also number 18 on non-discrimination and equal treatment of the Human Rights Committee. So in very common within international law, also within the regional human rights law, how we interpret or how we what was the content of the principle of non-discrimination, or what do we include under this, or which grounds do we include? It's usually sometimes it's prescribed, so it's clearly stated which grounds are prohibited. Sometimes we interpret them, usually involving something which is evolutive interpretation or dynamic interpretation of international documents. So in the case law, the Human Rights Committee has found a violation of Article 26. This is the Article 26 of the International Covenant on Political and Civil Rights, and has found a breach of Article 26 on the grounds as sex, and also put in brackets the case law. If you're more interested, you can check these cases. Nationality, Sexual orientation, very interesting because we don't have this in a general international human rights beside declarations. Sexual orientation as a prohibited ground. And also, interestingly, economic, social, and cultural rights. You're aware that there is a different document, different international instrument, Convention on Economic, Social, and Cultural Rights, which actually protects social, economic, and cultural. But nevertheless, Human Rights Committee applied Article 26 on the in the cases where discrimination happened in enjoyment of the variety of economic, social, and cultural rights, especially if you want to consider the case Waldman versus Canada. When it comes also some regional bodies, Africa Commission on Human and People's Rights has also dealt with prohibition of discrimination. I just put one case. This is the case Malawi African Association of the Elders versus Mauritania. Also, Inter-American Court has dealt with the principle of equality and non-discrimination. And very interesting, actually, that the court has indicated that at the present stage of development of international law, the fundamental principle of equality and non-discrimination has entered in the realm of use Congress. This is a very interesting statement. You know how we actually build the sources of international law. It's not just formal, it's also something which is part of customary law. And it's actually how Inter-American Court interpreted the convention in sense that actually principle of equality is actually use Congress of international law. Probably the most developed original document is actually European Convention of Human Rights. In Article 14, it states the right to equal treatment and principle and the non-discrimination. Additionally, there is a Protocol 12 in Article 1, which actually, in my understanding and the understanding some other authors, actually found a freestanding right of non-discrimination. There are so many cases in which European Court of Human Rights, which is actually a body who implements and protects the European Convention of Human Rights, where the court actually found the breach of Article 14. There are also cases in the brackets, so if you want to go into details, I'm just going to go through in which areas actually the court found the breach of Article 14. That's for example, employment, membership in a trade union, social security, education, access to justice, inheritance rights, access to children, eligibility for tax relief, freedom of expression, assembly, and association. And with this, actually, I will conclude. There are also other cases before different bodies, but I'm not going to go into more details into this. If you're more interested, we can talk about it after the lecture. And then the last part, I'm going to focus on how actually the principle of equality has been implemented in the national constitutions. So in comparative constitutional law, national constitution provide norms that establish legal principles of equality and non-discrimination and legal norms which enable their implementation. So I have somehow abstracted three ways how actually we protect the principle, or actually the general idea of egalitarianism is through the principle of equality. Second is affirmative action. And third, the principle of non-discrimination. This is very dogmatic analysis on so the way how it has been implemented before the courts or the constitutional courts or Supreme Court. It's actually I haven't dealt with this for this particular lecture. So how the principle of equality has been implemented? You're probably this is also common knowledge. For the very first time that we have a principle of equality has been established by the Magna Carta Libertatum and the Petition of Rights in a very specific context and for very specific groups of people. In a modern, I would say, UK constitutional law, this has been implemented by adopting the Human Rights Act in 1998. Other constitutions provide constitutional norms which guarantee the principle of equality. In which sense? So this is dogmatic analysis. So we're I'm just gonna try to put a picture of how different constitutions actually see or prescribe the principle of equality. For example, in Afghanistan, norm says men and women have equal rights and duties before the law. For example, Constitution of Albania and some other constitutions, put them in brackets, and also the articles says all are equal before the law. In Andorra, for example, national constitution prescribes that all persons are equal before the law. This is something which is more related to this principle of legal equality. Argentinian constitution is more detailed. It says that does not allow prerogatives of blood or birth. There is no personal, and it actually prohibits personal privileges, especially legal laws or court. This is more related to their social and historical context. Austria, for example, stipulates that all nationals are equal before the law, but also prescribes something which affirmative action we're going to talk about a bit later. It actually, the federation, landed and municipalities subscribe to the de facto equality of men and women. We also have some other constitution who prescribe the same. This is also a constitution of Bangladesh and the basic law of Germany. In Canada, national constitution provides that every individual is equal before and under the law and has the right to equal protection, A, B, and equal benefit of the law without discrimination. For example, also People's Republic of China, or equal before the law, very abstract definition, and also some other constitution, for example, Democratic Republic of the Congo. Interestingly, this is actually can be seen, this socialist inheritance and the socialist concept in Cuba, for example, and also prescribe that all people have the right to enjoy the same public spaces and service facilities and to receive equal salary for equal work without discrimination. Interestingly, Constitution of Cuba, some other constitutions have introduced some other grants which can be considered as prohibited for discrimination. These are sex, gender, sexual orientation, and gender identity. Interestingly, this constitutional provisions besides Cuba has Fiji and Constitution of Malta. In Ecuador, they have separated their guarantees for the right to formal equality, material equality, and non-discrimination. Indonesia is more detailed in the sense that provides everyone the right of recognition, guarantees protection, and certainty before a just law. Interestingly, we have here something which is more substantial, not just formal equality, saying that law has to be just. Second part in which this idea of egalitarianism has been implemented in national constitutions, actually taking different ways of affirmative action. So I'm going to just repeat it once more. Affirmative action can be directed to abolish factual inequality between men and women, among different social groups, for the person without disability, etc. So it depends on the social context. For example, the Italian constitution stipulates the duty of the republic to remove those obstacles of an economic and social nature which constrain the freedom and equality of citizens. Similar has the Constitution of Montenegro. And lastly, the principle of non-discrimination is the third principle. In my view, in my opinion, how this concept of egalitarianism has been implemented, and there are so many. Actually, there are many constitutions which have this principle directly stipulated within their constitutions, and usually some of these constitutions also provide a definition of what discrimination means. For example, Solomon Islands, Zambia, Grenada, Botswana, etc., etc. So thank you for your attention. I think I was, yeah, 30 minutes, so more or less on time. I'm gonna give the word to my host now. But I can't hear the host. I think you should you have to unmute Mohit. You have to unmute, sir.
All right. Okay. Sorry. Yes.
Mm-hmm.
Am I audible, sir?
Yes. Yes.
Okay. So first of all, thank you so much for summarizing the whole concept of equality, both in within national and international spheres. So, of course, this is a question and answer round, so participants can ask. So, before anyone asks, I have a question from you. Like, you just mentioned 4 concepts of equality. I mean, there might be more than that, but like social, political, legal, and economic. So, do you think that there is any hierarchy among these concepts of equality, or should there be any hierarchy? Because let's say there we talk about there is political equality, there is economic equality, and there is also legal equality. So, if we have 4 kinds of equality, and if we don't have social equality, so what will affect how these other equalities will be affected? So, do you think that social equality should be achieved first, and then we should talk about? So, your comments on this, please.
Actually, I can't give you the final answer because it's different from the doctrines or the concepts. What's actually primarily, I mean, can we talk about the political equality without social equality or economic equality? It's very hard. If you don't have enough income, you're not really considered about to politically participate within the society, or I mean, for you, political participation it's not your priority. It also depends. I mean, in my personal opinion, without economic, you can't talk about political. It's very much related to each other, especially because I'm coming from a very specific context in which we had something as an idea of economic equality, and then you have so-called 3/8, like enough time also to when your basic needs are satisfied, then you have enough time, and also you're interested in the political activities. But I would say I mean, economic can be divided, can be actually separated from the political. To put a hierarchy in a theoretical, at the theoretical level, it depends from which point of view are coming, or from which perspective we're coming. But I would say in order to reach equality in one society, you have to make some kind of contextual concepts. So it depends from Bosnian case, Indian case, Switzerland's case, and then you can see how actually what are the best models to achieve equality at national level. So maybe I assume for Switzerland economic something which is economical, social. So I mean maybe social equality in sense sense of equal treatment between women and men. It's something, yeah, it can be also problematic for Swiss society, but I would say we can't actually talk about I want to go into some general concepts, very abstract concepts. I would my idea is always to contextualize these concepts, and then to see what's actually first and what's the second in this sense. It's political representation, also the way to reach something which is economic equality. Probably this is more for sociologists and political scientists who actually do this empirical research, and this is actually something combined. We should do it combined, like sense how actually to provide legal aid in order to achieve something which is also economic and political equality. So sometimes you can't reach economic equality if you're not politically participated in this society. So if you don't have the voice in the parliament, or if you don't have a voice in the government, sometimes you can't address your issues, economic issues or social issues. So I would say I wouldn't say there is a hierarchy, and we should put some kind of hierarchy. But in order to achieve equality as such in one society, there should be, I think, there should be some contextual models, so to say. So for the Bosnian societies, what actually should be priority, and what should be of secondary importance.
Yes, absolutely true, sir. Thank you for answering the
Thank
question.
you.
So I think we have a couple of questions from the participants, so we will take one by one. So I think Kartike had asked, equality among equals, to what extent it is practical in your opinion, and how preferential treatment is making it feasible?
Actually, I'm not really. I'm not really getting what does this equality among equals. To what extent it is practical, in your opinion? How preferential treatment is making it feasible? I'm not really sure. In what sense equality among equals?
Okay, so maybe Kartike can ask the question more better.
Maybe if Kartike can. I just need some context in sense. So in which direction?
He is not right now. He's not. So maybe we can take another question and.
Okay, thank you. Sorry.
So now it's okay, sir. Because I think if it was, because in Indian context it should be like equality among equals is not a concept. There is there is concept of even there might be discrimination among equal, that is based on the reasonable classification, as you also mentioned. There should be reasonable classification. But okay, so I think it does not suits to my idea. So maybe we can take question from Adnan.
Okay.
Adnan, please.
Am I being heard?
I can hear you.
Okay. Thank you very much for your insightful lecture, Professor Banovic. It was really useful to me. My question goes like this. To what extent is applicable in practice the principle of equality in general, bearing in mind the fact that this principle is guaranteed by international and domestic legal acts? Also, I would like to say a statement, taking into account that nowadays we see a lot of discrimination cases, preferential treatment, and human rights violation in so many aspects of life. To what extent this principle, very important principle, is applicable in practice? Thank you very much.
There's always, thank you. I mean, history teaches us that equal treatment it goes ups and downs. And I mean, we wouldn't be talking about the principle of equality if we had it in our societies. Once when we reach them, it's going to be obsolete to talk about it. So but if you go through the history, I think we are more equal than we used to be. Usually my mind goes through women's participation in the politics, for example, and protection of such indigenous peoples. So the practice always differs from the concepts, but we can't do anything without the concepts. And secondly, we can't do anything if we don't have international documents, regional documents, and national constitution, which actually prescribe. This is something, that's why we don't talk much more about something which is natural justice, principles of justice, or something which is out of the legal sphere. But in my thinking, if we have something which is there, which is seen, some bodies, regional bodies or international law bodies, there's always a way to fight for equality within our society. We have decided, I would say, in general, that we're not going to fight each other in the sense of physical fights or wars. So this is the way how we should fight within our society to reach something in what we think as should be equal treatment. So definitely practice differs from the norms, and the difference from the principles. That's practical normal. Especially, for example, if you see the situation with the COVID, how actually this different social circumstances actually influence the equal treatment, or something which we have already reached. But I would say this is ongoing if I can use this ongoing fight or battle, because without these principles we can't go anywhere. So yeah.
Thank you very much for your response.
You're welcome.
Okay, so we have next question from Abid Khan. So question is, how one can protect the equal rights of the minorities where the government is of majority group? Whatever the constitution says, it's the responsibility of the government to protect the rights. So I think, so you can also see what is going on around the world. There is a rise of authoritarian governments. Of course, you can see in US or UK, there are democratic governments which are converting in terms of becoming more authoritative than they should be. So how do you say how a minority can protect his or her rights when the government is from the majority group, as asked?
It also depends of what kind of governments we're talking about. If you talk about multicultural systems, then you have the right to be represented in the government. For example, our system actually protects 3 ethnic groups. So you have the secured places within the government. But within the systems who are based on majoritarian system, within the states who are based on the majoritarian system, something. I mean, this is true. It's actually something is part of constitutional culture. There is no in legal terms, there's no effective means to protect you if you have a authoritarian regime or regimes who are inclined towards authoritarianism. You see this, for example, I mean, Belarus is something which is. I mean, if you read the constitution, it protects equality and non-discrimination, for example. But that's just a letter on the paper. And if you see the rise, for example, authoritarianism in Hungary and for example, in Serbia and in some other states, there is I would say there is no effective legal measures to protect minority if that's if the basis is not democratic. So. How can I protect equal right of the minorities where they belong to a majority group? Actually, my idea, if you're still talking about legal measures, there are ways, either political measures or actions that can be taken. For example, to boycott elections. This has been shown as a very good way to draw attention of international community. For example, in the case of Serbia, if you have followed the last parliamentary elections, actually the opposition boycotted the elections. So basically now you have one party system in Serbia. Actually, one party is actually presented in the National Assembly, and this concept, I was against it, but secondly, it draws the attention of the European Commission, the European Union, that something it's problematic within the Serbian system, and then that actual opposition should have the same set of opportunities to present their program and also to be represented in the government if they have, of course, the majority. So that's one way is actually political measures. That's part of political sphere. Second is there are so many cases before the European Court of Human Rights. So how do we? I mean, even though there are so legal ways how you deal with some kind of I would say a right to be politically represented, it also draws attention of the European Court of International Community that something should be done. So you have the possibility of some international pressure to change either your legal norms or constitution or political practice. For example, we have in the Bosnian case, the last case before the European Court of Human Rights has shown to be successful. We had the problem with Mostar. Mostar, it's a town in Herzegovina which didn't have elections, local elections in the past 12 years. So one citizen of Mostar, Irma Baralia, she launched application against the policy before the European Court of Human Rights. And now this year actually is the first year in which most will have a local elections, to put it simply. So either political ways, or so political actions, or to take every legal steps or legal measures which you have in order to focus attention on the problems of political presentation of minorities. Yeah, that's my more or less practical ways how to deal with these problems.
Thank you, sir. I think we have one more question from one of the participants, Katrina. Please. Katrina, you can unmute yourself and ask question. I think you have raised your hand. Hello, am I audible?
There is yeah, maybe I don't know who's there is no name. Maybe he or she can write the question. If,
whoever it is, everyone is most welcome to unmute and ask your question directly. So we have a very small audience, so we can have that discussion.
Maybe we can go to until the person I don't know who is this asks question. Maybe to this. Maybe you can more contextualize.
Okay. Katrina has.
Okay. Okay. Maybe yeah.
Okay. I think
this is more as a statement. Yeah, of course. When I was writing this article on comparative constitutional law and the idea of egalitarianism, yeah, of course, there's some. I mean, in the preamble of Indian constitution is draws the inspiration from the I would say Western constitutionalism, but this is also, this can be good in the sense, okay, there are some principles of equality which can be used for our purposes, but it's actually you have also contextualize the problems. I mean, the context problems should also be placed in the constitution, and also the social norms are usually much stronger than the legal norms. I mean, everyone who's coming from the reform states or state who want to actually change something within the social practice, you can see how it's actually this long process of changing social habits. I mean, some democratic principles you introduce within the constitution, but you need years and years of practice. So changes within the social sphere in order to change something which you see as a problematic, or it's morally wrong, or morally debatable within one society. I think Katarina Korzica has also a question because she has raised her hand. I can't hear. Can you, Imran, can you hear? I can't hear.
I have unmuted her, but
I'm so sorry, but I can't hear. Maybe if you can write a question. Until our.
No, actually, we cannot hear you.
Yeah, I can't hear. Maybe if. Maybe you can try mute and mute. Maybe it will. Maybe it will work. Yeah.
So, okay. In context of Indian Constitution, I just wanted to tell, especially to the participants who are not from South Asian region and who have a very minimum idea of Indian Constitution. Of course, the content of Indian Constitution has been taken from several constitutions, from Canada, Germany, and Russia, US, UK, so many countries. But what the Supreme Court has done in last 70 years, it has contextualized in Indian, it has completely, there are principles which might be similar to UK, but when you apply to India, it may seem different. The same principle may not be applied to India. So, and also Supreme Court has developed the jurisprudence of the Constitution. So we have Article 21, which says equality before right to life and personal liberty. But that Article 21 has the longest jurisprudence in terms of the whole part third of the Constitution, because from right to life to right to livelihood, from right to privacy, the new rights that are coming, those kind of rights are put on the Article 21. And what is the most interesting thing about the Indian Constitution and Preamble? This, I ask question because in the Preamble, one of the Supreme Court judges writes about the Preamble, where Preamble says, we the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. In the same way, there is also a guarantee for the protection of right, that is to protect equality, liberty, and fraternity. So Supreme Court judge in one of his books says that these words, equality, liberty, fraternity, has been put in particular manner. They are not there just because they were put. Equality has been preferred over fraternity, and so on. Right. So in Indian Constitution, the equality has been preferred over the freedom. Right. That's why equality comes under Article 14 and freedom comes under Article 19. So there is a quite interesting thing about the part third of the Indian Constitution. So this I just wanted to tell because I found this interesting. Yes.
Yeah, I mean, in my sense, conceptually, it's a problem. Like these two principles: one is equality, one is liberty, and they there is possibility that they're gonna clash against each other. I was talking about when this idea of these types of when I was talking about the types of legal equality, but also these contra arguments. This contra argument is actually argument coming from the principle of liberty. So equal treatment actually means that you're going to be forced to equal it. As I say, forced to be equal or equal distribution, even though you're much better in I don't know, in arts and mathematics, or as an entrepreneur, for example. If I earn more money, why should I be punished because someone is not able to earn it? So this is very it's not easy question to answer. I mean. Aristotle in his Nicomachean in Ethics and Politics has dealt with this, so we're still dealing with these issues. So it's still ongoing process. Maybe if we can't hear Katarina, maybe if she can write. I'm sorry not to hear her. She wrote the question. Sorry. Maybe can you, maybe I should read it on loud for the others. So the Indian constitution is inspired by various constitutional models, of course, drawing heavily on comparative law and explaining some passages developed by the constitutional jurisprudence of legal systems. The Indian constitution deals with the delicate balance between the protection of the rights of individuals and minorities. In the search of the balance point, for example, the duty of exclusion provided for by the caste system of traditional Hindu law, which provides for physical alienating individuals from lower and impure case avoid contamination, quoting. It is overturned in the diametrically opposite principle of the prohibition of exclusion according to the Constitution. The preamble of Indian Constitution is evidently in continuity with the great experience of Western constitutionalism. And actually, what I also want to add, I mean, every constitutional or either Supreme Court or Constitutional Court, depending on the system, it actually helps us to contextualize what does this means, principle of equality, what does this mean in a particular context, in which what is more important, political, legal, social, economic, and how we actually contextualize more this within our specific system. So, I mean, you're aware, if you say principle of equality, equal treatment doesn't mean anything until we come to the social ground, how people actually understand this, what are the I would say more important, whatever that means, what are the more important social interests, peace, security, political representation, or which are more present within the society, so they force the system to go towards this definition. So without constitutional court as a prerequisite, actually, it helps us to make more content of these principles. and to see which principles are more important within this particular legal system, I would say.
Thank you. I hope, Katrina, your question or query has been answered. Or
Anupa Arial also
yeah,
have a question.
Anupa has
Thank
a
you.
question.
Thank you.
Hello.
Hello.
Am I audible?
Yes.
Okay. Thank you for a wonderful presentation. I really enjoyed it.
Thank you.
For me, like I'm from Nepal. By the way, I have to mention this because my question relates to it. So from the presentation, what we can conclude for now is that no constitution can be purely egalitarian.
Okay.
Can we?
Yes.
Can we? Yeah. So I wrote a paper like in my first semester regarding constitutional migration of affirmative action. Nepalese constitution is, Imran mentioned that our constitution is highly inspired from Indian constitution as well. So positive discrimination is a means of ensuring equality or bringing the marginalized community to the forward was adopted by India in its very early stage. And Nepal, despite the limitation that India was facing, adopted it to Nepal while in the 2015 constitution and 2007 constitution as well. But what it actually did was, ironically, like the term Dalitization was introduced to Nepal. I don't know if you all are aware about it, Dalitization. Can I just get a nod if you know about it?
I don't know if everyone. Yeah, maybe in a couple of sentences, if that's possible, maybe. Yeah.
So, Dalitization, like Hinduization and Christianization, is ensuring a certain identity, giving identity to certain group. So, giving identity to Dalit community in a very simple term, it is very vague, but in very simple term, it means that you identify a certain group by their identity. Then the term like Dalit were identified because of them being Dalit. So this is the Dalitization. So in Nepal, what happened was Dalit were fighting for like years and centuries to come out of their status is the lower marginalized community. But when this concept was, like transported to Nepal, then they were actually, like tagged as Dalit. The term they wanted to escape for life actually became their identity. And right to Dalit actually is the fundamental right in Nepalese constitution. Um, so in summary, this were all the story. In summary, I think that while you migrate something, like even if a constitution is to be purely egalitarian, it cannot, because you tagline communities is the unequal one or the marginalized one. Don't you think? I know. I hope you get it. I don't
Yeah,
know. It
I got
became
it.
very long.
If I got it, I mean, when you migrate, I mean, some of my colleagues used to work comparative law. They wrote about this migration. This can be it can be very useful, but it can also be very problematic. In a sense, when you implement this some norms in the society, it doesn't actually work. It's actually more. It makes more. It makes discrimination even worse. That's your opinion, if I am correct. Anupa, I think she.
Yes.
If I
My
yeah.
opinion, as well as the question as well, because I can give example of my constitution because I am aware of it. But there might be situation all around the world where in the name of ensuring equality, they are actually marginalizing such some community and creating a more, like a loophole. And
Yeah,
in the
yeah, yeah.
name of ensuring equality, there is more inequality.
Yes, yes, that's actually that's something which I also understand. Yeah, we have to be very cautious when implementing some principles, either equality or freedom or liberty. It's actually when you implement them, it can actually drive more to inequality. So because the norms of equality or the constitutional, constitutional norms are highly abstract. So when you try to implement them, it can be one, two, couple of solutions concerning one case. So it's actually, it can be very dangerous. It can be really problematic if you purely implement some concept from Western constitutionalism, whatever that means, to something which is obviously non-Western or has a different context. So if you implement these norms or if you prescribe them within the constitution, it can be very problematic in sense. Here in our, for example, in Boston Constitution, it's more towards equality of groups versus equality of individuals, and this can be also problematic in sense. But I mean, in order to, in our context, actually, the Constitution stands that we have first to reach equality among the groups, and then we can talk about liberty as such of individuals, because it can be also problematic if say groups are equal. So what's within the liberty within these groups? So it can be problematic. So you can be marginalized within this particular group if you don't take the opinion of majority. So this idea of equality can be also problematic, I would say, depending on the context.
Okay, thank you, sir. So I think we have already done a session of 1 hour. So I think, Katrina, would you like to try once again? So I think the question is, if you maybe you can try, if we can hear you, so you can ask your question if you are interested in asking the question, or you can just.
I think maybe she can't hear us now.
I'm not sure. So maybe I think she's writing something. Maybe.
Okay.
Okay. Yeah.
Listen me.
Yeah.
Yes, we can hear you now.
Listen me.
Yes, we can.
Okay. Thanks for the answer of my comments in chat.
You're welcome.
I'm an Italian student, and in this moment, my research is on the freedom of religion in a comparative study. And the egalitarian in this webinar is for my research is important for the integration in my research.
Thank you for your comment.
Okay, so I think we don't have any more questions.
No, thanks.
Thank you,
Okay.
Caterina. Molto piacere, grazie.
Conosci l'italiano?
Sì, imparo la lingua italiana, sì, un po'.
The English language, in this moment, I practice always reading, listening, but speaking less than reading and
but I mean, we all very much understood your question or actually your comment on this comparative issue. Thank you very much.
Thanks.
So thank you so much, sir, for joining us. So I just, before we wrap up, I just wanted to add you to what Anupa was discussing with us, what happened in Nepal. Anupa, I also believe that there are people there. Let's say there is a group of people who may be called, who were Dalit, and they wanted to come out of their position of being Dalit. But that does not mean that they want to come out of their identity, because someone's identity as a Dalit is not problematic. The problem is considering them lower than the other people. For example, there was a time in Germany when Jews were kept in ghettos. So Jews today are not problematic. They have the dignity. They enjoy their own identity, being a Jew. So Dalit, as a Dalit can enjoy, provided we do not see them as second-class citizen or less privileged people. So maybe I don't know what was the intention of the Parliament of the Nepal behind bringing this word of Dalita and maybe giving them some kind of freedom or more privilege. But we can see someone's identity, because when we say someone is trying to come out of his or her no, bad position in society, it does not mean they want to escape their identity. Right? So we can see that in that context also. So this is my understanding. So I think we have come here, come at the end of the session. So thank you, sir. I would like to thank you once again on behalf of the whole team of ISLR and all the participants. So just a quick announcement that in the last week of this month, we are having one national conference that will be absolutely on the Zoom, and that will be a virtual conference. So you all are most welcome to join for the conference also, and you can present your paper and research working papers also. So I will request participants to hold for 1 or 2 minutes. We will in the chat box we will share a feedback form so that you can get a certificate also, right?
Okay,
So
that's
because
not for me.
actually the idea is simple, that we had received a registration of approximately 70 people, but approximately 15 to 20 people joined for. So I think a reward should be given to the people who have joined the session, right? I think
Usually that's
yes, it happens. So this was the idea of the team, that we should reward those people who have joined the whole session, and right. So the people who have done must not feel bad that equal reward is being given to the people who have done nothing, right? So this is all. So thank you everyone, and thank you sir for joining us. Maybe in future we can have more session with you. We can actually some of our students who are working with us, they are interns, and they have just started studying international law. They wanted me to ask you for one lecture on specifically Kosovo and Herzegovina, the whole international criminal trial that happened after the horrors, right? So how international law actually shaped the making of a country, in a new way, we can say, because such kind of horror has not been seen in South Asia, right? So we have really no idea. We don't know how to react, what we will do, what will happen, because if you see, South Asian countries are third world. So how much we respect international law, we know, and the world also knows, right? So there is only one South Asian country which has signed the Refugee Convention, in spite of the fact that we are having a huge influx of refugees. So there are issues. So maybe in future we can have one request from you to have one session on this international criminal trial that happened in Kosovo. Right?
We can discuss this.
Yeah, sure. So,
yeah, okay.
So we'll discuss about it.
Thank you for the invitation once more. There is a, separate paper which needs to be published. It's in the process of reviewing for the encyclopedia. So after the review is done, I can send this paper, but you can use this presentation if you find it useful. So there's some I'll say very I put in brackets this case law. If you want to go more into details into case law. Also, there is a lot of theory in political philosophy about issues of egalitarianism and problems with egalitarianism. So you can share my presentation. There is my email address. If someone is interested in more details, he or she can contact me. Thank you very much.
I think it will be good if you can just write your email in the box.
Okay, that would be much easier. Okay, this is my formal address. So yeah, this is me.
Yes.
And